Howdy, let's finish chapter 2. We're going to talk about common law data breaches causes of action. Be aware that I do not have detailed slides on this, so listen up. You have a list here. I'm going to go through them rather quickly. Contract breach. Express means you have a written contract in place. I'm taking your private data, your personal data, and I have, in the terms of service or something, there's you've agreed to certain conditions, and I have put in that contract that I will use all reasonable means to protect your data, and then I don't. That's an express contract breach. Implied is where you have either a verbal contract or you have a business transaction, and there's an implication, okay? There's breach of implied warranty. If I go to Home Depot or Lowe's and buy a ladder, and the ladder doesn't hold my weight, well, that ladder should be, and so it's not fit for purpose. So the breach of implied warranty has been tried in if you're holding on to someone's data, isn't there some kind of implied warranty? Negligence is a good one. It's tort. Is there a duty? Was the duty breached? Was there an injury? Can that be traced back to the defendant's bad behavior? And was it foreseeability? Now, those are the top. Contract breach and negligence are the top cases I've seen. Let's look at the others, and then we'll go back to this. Unjust enrichment is this. A non-cyber security example would be, I'm your financial planner. I take $100,000 out of your account, put it in my account, put it in Bitcoin, and catch it when Bitcoin's going up. You catch me at it, and I say yes, and there's statutory interest of 2%. So you can have your $102,000 back. But in the meantime, I doubled the money. I should not be allowed to keep that. By the way, not all states have unjust enrichment as a cause of action. We do in Texas. So I've been unjustly enriched, so you get the money, right? You were the one that I took the money from. There's fraud, where you say you're going to do something and you don't. There's slander, where you say something against people. There's invasion of privacy, publication of private facts, negligent misrepresentation or omission. The biggest one you'll see in data breach cases are contract breach and negligence. And here's the deal. If I could go through and pick out a couple of these, why would I pick out negligence over contract breach? I may put in my pleading, remember where I went through how the plaintiff puts something in court to initiate the action. I might say both, just in case the judge throws one out. But between the two, I want negligence, because contract breach damages puts me just back to where I was before. Negligence, cha-ching, there can be punitive damages, there can be exemplary damages, there can be additional damages. So I'm looking to maximize the return. Now, let me go back to class action suits to make sure you understand this. They tend to be federal, tough to do in Texas. They have definite procedures before being certified. And until certification, the class is putative. And it's not like I'm going to file a motion, file the paperwork to get this class certified. Here it is, judge, check off the box. No, it's not like that. It's a long process. So in the meantime, the putative class, the class that's hoping to be certified, will be getting their legal strategies and everything together. Again, you see these at federal. Texas, it's very hard. California, it's a lot easier to do a state level class action. Texas has made it difficult. Privileges, attorney-client privilege exists to keep the communication, can be only waived by the client. And if I have work product communication with the client, I'll mark it into anticipation of litigation to protect it against discovery. Okay, so let's go back to class actions. Must be certified by a judge in a class action suit. It's one or small groups of individuals are named representing the class. So in other words, it's Paula DeWitt representing those victims of the data breach of such and such a place from such and such, and it's thousands of people. But you name an individual as being representative of that class. There's 4 elements, and again, I don't care. He goes through a lot of detail on this. Go to law school if you want to do that. The class is so numerous that having individual suits is not practical. So we have tens of thousands of people who had the same incident. So let's just put it together in a class action. The facts are going to be common. The data breach is going to be common to all of them. All of them had their data stolen the same way. The claims are typical and the defenses are going to be the same. So the plaintiff and the defendants are going to have a legal strategy for all the members of the class. And then the representative parties will fairly and adequately protect the interests of the class. That polity, I'm the one that's being named, okay? Adequacy. Not important to know. What I want you to know is tough to do. You see them a lot in data breach classes. But when you see that it says putative, you have to understand it has not been certified yet. And it may not be certified. Here's what you need to take away from this chapter. Data breach law is unsettled. I have taught this class since 2018. I've gone through now, several versions of the book. I monitor several blogs on this. There's a lot of inconsistency. I look at 5 or 6 blogs every morning to see if anything's changed overnight. It's unsettled. And unless it goes to the Supreme Court, we still have different ways the laws are interpreted. And that's the inconsistencies, the split in the circuits of the federal appellate. The Supreme Court, for whatever reason, doesn't like to get involved in these cases, so they have not made general, widely applicable results. And I've put yet. The Supreme Court only looks at about 2 or 3% of the cases that are given to them, and no one can order the Supreme Court to do this. So what do? We try to interpret other laws. So there's something, for example, called the Uniform Commercial Code, and what that is buying and selling goods. Well, and then there's certain procedures in it, and you just defer to the UCC. Because if you're in a business-to-business relationship, you defer to the UCC. Not the consumer to business, but business to business. And so you have the state common law, you have these statutes, you have this UCC code that has, every state has implemented kind of their own version. And then there's this commonality. And so that enables faster commerce. You're not constantly have to, renegotiate contracts. You're deferring to the UCC. But it's for physical goods. So attempts to use the state common law, the causes of action that I showed earlier, and statutes just like the UCC have mixed results. But it goes back to what I've talked about before. We are trying to interpret existing laws to fit into this situation. With that, we're finished with Chapter 2. Our next chapter will be Chapter 5. I think it's one of the most important chapters. Well, I think most of the chapters are important. Some are less important, but most are important. But 5 is a very important chapter because it talks about the Computer Fraud Abuse Act. So until next time.